Hey, good morning, everybody, and welcome to Sunday Funday from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Good morning, everybody. Good morning or good afternoon or good evening, wherever you are calling from. Thank you so much for spending some time with us. It has been a busy but fantastic week, and I'm so glad that you all were able to spend some time with us on a Sunday to go over some of these incredible questions that you guys have put together. Hello to P. Lola's mom and Bess Nancy and Johnny Knoxville and Shy Gal. Thank you guys, and Afton, our new mods, for being here this morning, and CJ. This is going to be a good one. This is going to be a real good one. My name is Joshua Ritter. I am a former prosecutor with the LA County District Attorney's Office. I was there for 10 years as a prosecutor. I left and I went into private practice as a criminal defense attorney, and I've been doing that for nearly as long. This is Courtroom Confidential. For everybody who is new this morning, we welcome you. And the whole mission of this channel is to try our best to give you a perspective from both sides of the courtroom, and we hope that we accomplish that. We have, for the first time, this is incredible. You guys showed up on these questions. For the first time ever, we are just not going to be able to get to every single one of the questions. We don't want to sit here for 6 hours going through questions on a Sunday. I tried my best to answer questions. If you asked a question on a certain case, I made sure that a question on that case was asked. Some questions, somebody left a question and we didn't have audio on it, so I'm sorry about that. But where we could, we did our best to cover as many as we possibly could. But I will tell you this: you're going to stick around to the very end, because in celebration of making 30,000 subscribers, thank you all so much for your support. We are doing a 30K giveaway, and everybody who called in, whether or not I'm able to get to your question today or not, you are entered to win. So we will be announcing the winner at the end of this, and I'm very excited about that. So, yeah, thank you again. You guys showed up. This is fantastic. This is what we were hoping the show would turn into, is just a bunch of different questions from people all over the world, wide-ranging topics. You're every single week, you surprise me with the stuff that you guys come up with. So it's going to be really fun. So please, if you haven't already, subscribe to this channel. Please like this video now. Let's get everything going. And like I said, stay to the end, because we're announcing our winner for 30,000 subscribers. Our 30K giveaway is going to be one of these brand new shirts in a color of your choosing, and we will send it to you wherever in the world you happen to exist. All right, should we jump in? Should we get our map going? Let's do it, huh? If I can just figure, this is the nerve-wracking part of the show, because that means I have to actually start to do something technical, and this is where the wheels come off. All right, let's figure this out.
Hello, everybody. In case you haven't guessed yet, it's Becky here with the Belfast accent. So I just thought I would leave a quick voicemail for you all to hear it, because there was a lot of people asking for it. And hope you are all having a great day, and I'll speak soon. Bye.
Love it. Becky kicking us off, starting in Belfast, Ireland, just so we could have the pleasure of hearing your accent. I appreciate that, Becky. Please keep calling in, because I feel like I can't go another week without hearing your voice again. So thank you so much for calling in. Becky from Belfast, kicking us off. Let's keep it rolling.
Hello, Josh. My name is Lena. I'm calling from Norway. I have a question about not a special case, but about criminal law in the US. I understand there are different laws in different states, and this confuses me a bit. Are each and every state free to make their own laws, or do they have any basic laws they have to follow? Love your channel, and I will be listening. Bye from Norway.
Look at that already. already we hit a single and a double with our first two up, Belfast, and now heading to Norway with Lena. Thank you for calling in. This is there we go. Put it on the map, Norway. I think that's our first Norway call. So thank you for doing that. This is a great question. And this, I can understand confusing people around the world because we are a country, the United States of America, but we have a bunch of different states who decide to handle all of their laws differently. And that's absolutely true and can be confusing for other countries that just don't operate that way. And she wants to know, does each state make their own laws? They absolutely do. Each state has their own civil code, their own penal code, their own welfare code, their own, every single law that you need to deal with to govern a set of people. Every state has their own laws. Then we also have federal laws, which just apply across the US. I'm not getting into the weeds about jurisdictional issues and when the feds would come in and when the state would come in and when they both can come in, i.e. Luigi Mangione, he's being charged both on the state and federal level for murder. Sometimes that can happen. It doesn't invoke double jeopardy because they are considered to be separate sovereignties. So really great question. Here's the quickest of quick Cliff Notes Constitutional Law 101 version of why that is. The 10th Amendment to the Constitution says, the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. What does that mean? The 10th Amendment is kind of this catch-all saying, if we haven't talked about it, if Congress hasn't created a law, then that law is reserved for each of the states. So that has a lot to do with traffic laws and, municipal codes and things like criminal laws. Every single state's going to have its own murder law. Every single state's going to have its own burglary and robbery laws. And they're all reserved to the states. So when does that become a problem? Well, it only becomes a problem if you start to deal with how those run adverse to each other between different states. Now, usually that's not a huge problem. For instance, some states have made marijuana legal. Other states still have marijuana as being illegal. On the federal level, it still is illegal. So in California, where it's legal, you are not breaking any state laws, but you're technically breaking some federal laws if you're selling marijuana. So how do they deal with all of that? Well, it's sometimes confusing, but there is, again, I know I'm getting into the weeds. I'm going to try to do this quickly and simply. There is one instance where you can see this applied is what's called the Commerce Clause of the Constitution. I don't know if you've heard people talk about this or refer to it, but this is Article 1, Section 8. Clause 3 of the Constitution says, the Congress shall have power to regulate commerce with foreign nations and among the several states and with Indian tribes. And that among the several states thing basically says, listen, if what you're doing in California affects the business of Colorado or of Nevada or of Oregon or of Washington or wherever else, then we can get involved as the federal government. And then we can start to tell you as a state what you can and cannot do, because we're not going to allow you to affect the interstate commerce, the commerce between different states. That is something that we feel is reserved to the federal government. That's just one example, but you can see how this can get confusing. I will tell you, I am no constitutional scholar. I can't even remember the grade I got on it in law school, but that is how this interweb of laws works here. But great question, Lena, and thank you so much for calling in from Norway. Johnny Knoxville says, did the research on Bay Cities, Santa Monica and Huntington are my fave spots. May throw you a line next time I'm in SoCal. The deli is on me. I love it. I will take you up on that, my friend. We were talking about where do you get the best sandwich in SoCal, and in my view, it's from Bay Cities in Santa Monica, and you get the Godmother, and you don't You don't change a thing. You just say, give it to me with the works. You can ask for it hot or mild, and that's about the only change you should make to it, but it's fantastic. All right. Thank you, Lena. Ireland, Norway, where are we heading to next? Where are we going? Where are we fueling up the jet and going to next? Let's find out here.
Hi, Josh. It's Anita from Italy in Rome. Exactly. Thank you very much for your work and for your explanation, which are great and very, very clear. I wanted to ask you a question about the current retrial and the affidavit that the lawyer Bellerow just published or filed, actually. What is really an affidavit? And is it possible wouldn't it be foolish to file an affidavit with no proof of what they are saying? Thank you very much, and hope to listen to you very soon again.
Is this incredible or what? Ireland, Norway, and now we're going to Rome, Italy. Thank you so much, Anita, for the question. And I think that's our first time going to Rome. So fantastic. This is we're going to fill up this map with little dots before it's soon enough. All right. The question is, what is an affidavit? Great question again. We toss that term around as if we expect everybody to know. And can you get in trouble for putting something in an affidavit that is not factually true or is not supported by some sort of evidence? And the answer is absolutely yes. An affidavit, the best way I think to think about it, is as your sworn testimony in written form. An affidavit is given under penalty of perjury. You are signing it. You are saying that this is essentially either what I'm going to testify to or a substitute of what I'm testifying to. Many times when lawyers are trying to figure out definitions of things, we go back to the jury instructions, because that really is the final determination of what we have to define in court. So in California, we have the jury instructions are called the CalCrim jury instructions. And I looked up what affidavit was defined there, and it says an affidavit is a written statement made under an oath or affirmation given by a person authorized to administer oaths. Meaning, if you are old enough to give testimony under oath, then you are old enough to write an affidavit, and you are old enough to give that affidavit under oath or affirmation. And then just so we know what an oath is an affirmation or any other method authorized by law to affirm the truth of the statement. So to your question, Anita, you are swearing under oath, under penalty of perjury, that what you're putting in that affidavit is true. So it better be backed up. It better have evidence. You better be saying the truth, because if you're not, then you're subject to the same perjury laws as anybody who had taken the stand and raised the right hand and swore an oath to testify truthfully. So great question. When you see this term affidavit be thrown around, the reason why we use affidavits is many times you're filing a motion. You want to show that someone, you have witness testimony in support of that, but you're not going to attach a deposition. So you attach an affidavit saying, essentially, this is what this person would testify to, and that's why I am attaching this affidavit to this motion. Great question, Anita. I feel like I'm already out of breath. Is it just me, or are we off to a frantic pace already? I'm gonna take a breath and let the next question kind of come more calmly before I give myself a heart attack. But this is fantastic. Thank you guys so much for all these questions. Let's keep it going here. And Annalie Fitch says, great viewer questions as always. I completely agree. All right.
Hi, Josh. This is CB Kansas calling from Kansas City, Missouri. Put it on the map. And I really need a t-shirt, by the way, and a part-time job if you're hiring. Anyway, I guess my question for the t-shirt is going to be, can you explain the difference with the Bryan Kohberger and the Karen Reed case in respect to the, I guess the charges? So Bryan Kohberger bought the knife and the knife sheath, and the knife sheath at the scene had his DNA on it. How is that different? If you can explain the difference, so that we kind of get a clear example of what's actually needed. He explained how that's any different from John O'Keefe's DNA and hair being found on Karen Reed's car, which has been tied to her driving it that night. How are the two different or less, I guess, weighty in terms of proving the case? Thanks. Bye.
CB Kansas from Kansas City, Missouri. She says, put it on the map. Let's go ahead and put it on the map. Kansas City, Missouri, just to further confuse our international friends. Kansas City, not in Kansas, but in Missouri. Thank you so much for calling. I got to tell you, CB, when you first started this question, I thought, where is she going with this? I don't understand how are they any different? Well, one's a quadruple homicide and the other one's allegations of of hitting somebody with a car. But then I thought, once you brought it full circle, I'm thinking to myself, what a fantastic question this is. Great question. What is the difference between how they are putting together the Bryan Kohberger case based upon DNA recovered from the scene, and how they're essentially putting together the Karen Reed case based upon, again, DNA found on the scene? There's apparently John O'Keefe's DNA found on her bumper. Some other circumstantial pieces of evidence, but how are these cases really any different or any stronger? And the answer to that is they're really not that different. The results and the seriousness and the magnitude of them, I think, are arguably very different, but the way that they're being put together are very similar in the sense that they're both using circumstantial evidence. DNA is circumstantial evidence. It really is not different all that much from fingerprint evidence, from gunshot residue evidence, what we call GSR, from other just circumstances surrounding a crime scene that is not direct evidence. DNA somehow has taken on this idea of being somehow more important or more impactful. All it is far more precise and far more you need far less of it in order to find trace elements of it. But it really is the same thing. It's circumstantial evidence. It's saying that based upon this, we believe we can prove an inference from that. So we get a lot of questions about the difference between circumstantial and direct evidence. So again, I thought I would go to CalCrim, the jury instructions, and give you guys what the jury instruction is here. Now, it's a little bit difficult to read, so I'm going to pull it up myself and read it to you guys. Hold on. Okay. This is the instruction. Any case that involves circumstantial evidence, and almost every single case does, this is the instruction that will be read to jurors. And I think it probably does a better job, though it's using that same kind of lawyerly language of explaining it as I would. Facts might be proved by direct or circumstantial evidence or by a combination of both. Direct evidence can prove a fact by itself. It's direct evidence. For example, if a witness testifies he saw it raining outside before he came into the courthouse, that testimony is direct evidence that it was raining. You can prove that fact by itself. Circumstantial evidence also may be called indirect evidence. Circumstantial evidence does not directly prove the fact to be decided, but it is evidence of another fact or group of facts from which you may logically and reasonably conclude the truth of the fact in question. What does that mean? For example, if a witness testifies that he saw someone come inside wearing a raincoat covered with drops of rain, that testimony is circumstantial evidence because it may support a conclusion that it was raining outside. So let's think about that. You see a person covered with a raincoat covered in drops of water, that is direct evidence that that person's wearing a raincoat covered in drops of water, right? You can directly say that those are the facts I can prove. But it's circumstantial evidence because you can indirectly show that they likely was raining outside. Both direct and circumstantial evidence are acceptable types of evidence to prove or disprove the elements of a charge, including intent and mental state and acts necessary to a conviction, and neither is necessarily more reliable than the other. Neither is entitled to any greater weight than the other. You must decide whether a fact in issue has been proved based on all evidence. So I hope that does get us a little bit closer to the idea of understanding why CB Kansas's question is such a great question. They're both circumstantial cases. No one is an eyewitness, a direct witness, will present direct testimony that Bryan Kohberger stabbed 4 college students. No one's going to testify to that. There's no eyewitness to it. No one is an eyewitness to Karen Reed running over anyone. There is no direct evidence of that. Or if you want to take it the other way, no one's a direct witness that will testify to John dying any other way. But what we have is circumstantial evidence. We have DNA, which means that we can circumstantially say that Bryan Kohberger either touched a knife sheath or became in contact by some other means with a knife sheath that ended up at the crime scene. We can circumstantially say that at one point in time, somehow John O'Keefe's DNA got onto her back bumper, pardon me. Those are both circumstantial evidences because we can indirectly prove the ultimate fact that we're trying to prove in the case. That was a long-winded answer. I hope you're still awake. Take another sip of coffee. I thought it was a great question and it caught me by surprise. So thank you so much, CB Kansas, for that question. And thank you, Best Nancy, for gifting the Courtroom Confidential memberships. Appreciate you guys and your support for bringing us to where we are today. All right, let's keep it rolling. Let's keep it going. Hold on. I got to get my ducks in a row here. 224.
Hey Josh, it's Joanne M. Jedi Platypus. I'm originally from Tweed Heads, Australia, but I'm now residing in Reedville, South Carolina. I only have one question. Who or what inspired you to become a criminal attorney? Thanks a lot. Oh, by the way, Mr. Jedi, my husband, has a man crush on you and just has hair envy all day, every day. Thanks, Josh. Bye.
Thank you, Joanne /Jedi Platypus. I appreciate that. Please send my regards to your husband. That makes me feel pretty good. From Reedville, South Carolina, by way of Australia. Appreciate it, and I love your handle, Jedi Platypus. What inspired me to become a criminal attorney? I'll be honest, this was not the vocation I thought I would get into. I did not go to law school with the idea of becoming a criminal, involved in criminal law. Honestly, my father was an attorney. My brother is an attorney. They both got into civil law. They're both personal injury attorneys. And I thought that's what I was going to do. My main thing in going to law school was I thought I wanted to be a trial lawyer. I know I didn't have the attitude or aptitude or patience to be one of those attorneys that sits behind a computer all day writing motions and searching case law. And that is what the vast majority of attorneys do, right? The vast majority of attorneys will never see the inside of a courtroom, and they're all brilliant and they do great work. That was not for me. I just don't have the brain power for it. I thought I want to be in court. I want to be in front of people and a jury and convincing them and arguing and trying to think on my feet. And so I thought, well, I want to do that, but I also want to make money. I'll go into personal injury. I'll be one of those guys arguing about auto accidents and, you know, why you should give my client gobs of cash. The money makers, Vesper Martini says. Exactly. And when I was in law school, I don't know if I've told this story before. I was in law school. I took a trial advocacy class that was very difficult to get into. It was a fantastic class. And part of that class, though, you did one semester of in classroom trial advocacy, and then one semester as you were placed as a law clerk in the DA's office. And I didn't want to do that part. I thought, I don't know if I really want to be a DA. Because in my brain, and this is so unfair, but I thought of them as being kind of just like almost failed attorneys, government workers. Like, why would anybody go into that? It seems like, you know, that's not really where you want to end up, but that's kind of where you find yourself. Totally unfair. I started my clerkship in the DA's office, and I quickly found how wrong I was, because everyone I was working with was young, bright, aggressive, charming attorneys who loved what they did and had a passion for what they did. And I went from that first assignment to another clerkship in what's called the Major Crimes Division. That's where I eventually met Alan Jackson. I started working with him. He became a mentor of mine and a good friend. And I was just blown away by the talent of these people and the incredible seriousness of what they're working on. And I thought, this is what I really want to do. I was just inspired by how good these attorneys were and how complex and how important these cases were that they were working on. And the rest is kind of history. That's what it's like when you become a doctor. You kind of, you know, if you come out of medical school and you're a foot doctor, it's really hard to switch over to being a eye doctor after 10 years or so. So that's where I found myself, and that's where I've been ever since. And the only thing that's changed as I've gone from one side of the desk to the other side of the desk, from prosecuting people to defending people, but it's still that same world. So thank you so much, Joanne Jedi Platypus from Reedville, South Carolina. Appreciate you for asking that question. I'm surprised if I haven't told that story before. I feel like I probably did. All right, where are we at here? Moving on. Oh, Kay Schmidt, thank you so much for the gift of memberships. Appreciate you. Appreciate you guys so much. Everybody's so generous. All right.
I appreciate you getting to my question, Josh. This is Jen. I'm calling from Ontario, and I'm just giving a follow-up. I like that you broke down the hearsay rule that I trampled all over. I'll refresh you. It was about the video where Vallow Charles was begging for some help from Chandler PD. You said that it was rejected because it was hearsay, and it was hearsay Lori to Charles, and then it would have been hearsay also from a subject to a cop. But because Lori Vallow Daybell Lucifer in a dress texted about it all the time, and also sort of testified to that about with the cops that came to her Rexburg townhouse that time, saying that Charles Vallow was after her, etc. I thought it was excited utterance, and I like how you broke it down. You're a good instructor. I think you'd probably really be good because a law instructor. Have you thought about that? So I again, I appreciate that, and again, my name is Jen. I'm calling from Ontario.
Thank you so much, Jen from Ontario, Canada. Let's first of all put you on the map. Thank you so much for the kind words. Yeah, I remember your question. We talked about the Lori Vallow case. Charles Vallow had given some statements to police. They were captured on camera. She asked, why in the world can't we just use that in court? And I said, well, it has to do with the little thing called hearsay. Hearsay is an out-of-court statement offered for the truth of the matter asserted. And that is something that continues to confound attorneys to this day. What exactly does all of that mean? Well, anytime you're talking about some sort of statement made outside of court, meaning it's not coming out of the witness on the stand in the moment, even if it's that witness talking about comments they made themselves out of court, and they're being offered for the truth, meaning it's not to prove something else, then you can't use it. It's hearsay. Why do we have that? We have that because there is something called constitutional right to confrontation. You are allowed to cross-examine any witness presented against you, and that includes statements made outside of court. How do I cross-examine what Charles Vallow said if it was made outside of court and he's not present in court to question him on it? And you're trying to offer it to prove something. Now, all of the exceptions either lie in the idea that it's not offered for the truth or that it's got some sort of exception. An exception usually has to do with the reliability of the statement. So Jen brings up excited utterance, meaning something that you're saying in response to the excitement of the moment. Other ones can be present sense impressions, meaning somebody just talking about what they're feeling or thinking as things are playing out in real time. A lot of different exceptions, but none of those seem to apply in the Charles Vallow statements that he made to police, because he wasn't under the excitement of the moment. He wasn't talking about things that he was witnessing in real time. He was talking about something that had happened earlier or days earlier, and therefore the judge kept it out. But thank you so much, Jen, and thank you so much for the kind words. I appreciate you, and I appreciate you calling from Ontario, Canada. Oh, and happy birthday to Cornish Lass. Appreciate you being here. And happy birthday to you. And Carol Lynn for becoming a new member. All right, should we keep it moving? Let's keep it moving.
Hi, Josh. This is Kay from Red Bluff, Tehama County in far northern California. The case I would like you to give an update on is about Cameron Hooker. He kidnapped the 20-year-old hitchhiker Colleen Stan in 1977 and held her captive in his Red Bluff home for 7 years. He was convicted in 1985, sentenced up to 104 years. The law changed and now can be released for good behavior after 40 years. Tehama County DA is trying to get Hooker to be evaluated for designation as sexual violent predator to keep him in prison. This hearing has been delayed several times over the past few years. Can you give us an update on this? Enjoy your videos. Thank you.
Kay, this was a good one. Kay calling from Red Bluff, California, up in Northern California. Buckle up, everybody. This is why I love Sunday Funday. I've never heard of this case. I don't know why I hadn't heard of this case. It's absolutely horrific. When you called in, Kay, I had to do some research, and I did. And I got to tell you, the kind of rabbit holes it wants you to go down are pretty insane. So, like I said, buckle up, everybody. Colleen Stan. This is back in 1977. She's 20 years old. She is hitchhiking. Remember those days when we actually did that? She is hitchhiking. And she even says that she was being careful because she had some other vehicles had stopped and she didn't get into their car because she thought she just didn't feel safe about it. She gets into a van with Cameron and Janice Hooker. And the reason she does that, get a load of this, is because Janice had a baby with her. And she thought, oh, this must be safe. I'm going to get into a car with a husband and wife and their young baby. How in the world could this be dangerous? Well, what she didn't know is that Cameron had been violently playing out his bondage fantasies on his own wife for some time. And so Janice had agreed to allow Cameron to kidnap someone so that he could play out his fantasies on her rather than on herself. So that's what they were going to do. So they kidnapped poor Colleen Stan, and they held her for the next 7 years as a sex slave. And she was kept for much of that time in a wooden box under their waterbed. She was sexually assaulted and R-word, everything over those 7 years. Many times you'll see there, if you can't tell in the bottom left, that is a picture of a box that was put over her head many times. If she wasn't actually held in a small container, she had that box on her head. It is beyond horrific. On top of this, they had psychological torture where they had convinced her that she couldn't ever escape, because if she did escape, she was under constant surveillance by something called the company. And the company knew where her family lived, and if she tried to escape, her family would be killed. So because of that, she actually had opportunities to escape over those 7 years and didn't do it. At one point, she even visited her family with Cameron and didn't tell them what was going on because she was in such fear of the company murdering everyone. And her family thought that she had just joined a cult, and they were just so glad to see her after so long not from hearing from her, that her family just kind of embraced the moment and felt bizarre about it, but were just good to have a moment with their daughter and didn't call police, get involved, try to bring her back. Just horrible, horrific, and a lot of mystery and everything surrounding the whole thing. So the way this all plays out is that Janice, and this is part of the story that will put you, if it doesn't already put you through the roof, this will put you through the roof. Janice strikes a deal with the government, and she's granted immunity for her cooperation. Chalk that up to whatever you want. I think it was the idea that we need to nail this completely evil person, and even if that means we let someone who was complicit in it get away. And Cameron is sentenced to 104 years in prison. Now, this brings us to Kay's question was, there has been a change in the law, and he has now been, he will be soon eligible for parole. What do you do with someone like this? You've got an absolute maniac on your hands who's eligible for parole. Well, California has something called a sexual violent predator designation. And that's what Kay was asking about. According to the Welfare and Institutions Code in California, a sexually violent predator means a person who has been convicted of a sexually violent offense against one or more victims and who has a diagnosed mental disorder that makes that person a danger to the health and safety of others, and it is likely that he or she will engage in sexually violent criminal behavior. So someone who's committed acts of sexual violence involving force, violence, duress, menace, fear, and they have a mental disorder. What do we do with them? If the criteria is met, and they will actually have a trial to prove this in front of jurors, if these criteria are met, a civil commitment petition is filed with the court, potentially leading to indefinite confinement to a state hospital for treatment, meaning we've decided no. Sometimes doing your time is not enough. You have demonstrated that both through your propensity to commit sexual violence and your mental health disorder, we don't feel it's safe for you to just walk. So this is not criminal, by the way. It's a civil commitment that will put him in a state hospital. So that trial is expected to take place this year. And I am fairly positive they will be able to reach the criteria involved here, and that this monster, Cameron Hooker, will likely remain in a state hospital for the rest of his life. But wow, what an absolute story. Apparently there's a documentary about it called I think it's called The Girl in the Box. I haven't seen it. Just nightmarish type of stuff. Very, very sad. But thank you so much, Kay, for asking that question. Did you think you'd be talking about that case this morning? No, you did not, Mr. Ritter. All right, let's keep it moving.
Hi, Josh. It's Sleuth Raffaella from Melbourne again. Absolutely love your show. I've also been following the Kohberger case really closely too. And I know the defense might bring in a neurological condition like autism, but I'm not sure if you ever caught the brief mention that he might also have visual snow syndrome to suggest that he's somehow incapable of committing the murders. But if that's true, couldn't it actually help the prosecution by explaining why he didn't see DM, the surviving roommate, as he left the house? That's always baffled me, and probably a lot of other people too. Wouldn't that actually place him at the scene instead of ruling him out? And if his alibi is that he was out stargazing, wouldn't a condition like visual snow make stargazing pretty unlikely, maybe even impossible? Have a brilliant day. Aussie, Aussie, Aussie.
Raffaella from Melbourne, Australia. First of all, let's put you on the map. Thank you for bringing Australia to the conversation. What a great point. I loved this, and I am kicking myself. I hadn't thought of this myself. Yes, there is. I don't know if it's ever come from the prosecution or from the defense, but there has been discussion about whether or not Bryan Kohberger suffers from something called visual snow syndrome. I think where this came from is that there's a person who was online in certain chat groups that was suspected of being Bryan Kohberger, and he talks about having visual snow syndrome. And I think he may have even in some of these psychological evaluations talked about having it. What is visual snow syndrome? It's where a person has a constant perception of flickering dots or static in their visual field. And here's kind of a representation of that they would have these kind of, the reason they call it visual snow is it's like looking at, if you can go back to the good old days when you had televisions that you wouldn't have a channel that came in and you would get that static, that snow on the screen. That is the best way of kind of representing what these people who suffer from this are looking at. And it sounds like it's a constant issue. I don't know enough about it, if it comes or goes, or you have good days or bad, but if he did suffer from this, might that kind of put holes in some of, first of all, his alibi that he was out stargazing? Does somebody who suffers from this condition, is that even a hobby they can take part in? I mean, putting aside the ridiculousness of the stargazing alibi, but even if, wouldn't this kind of cut into the credibility of that? And might it explain, just for our own curiosity, why in the world the man in the mask with the bushy eyebrows didn't stop upon walking nearly past one of the surviving roommates? A question that many people ask, a question that many people are terrified by. Why wasn't she also a victim? I've thought a lot about that too. And I thought, well, maybe, we don't know how this played out. We have such little information that we're trying to do so much with, but we don't know if she peeked out of the door, if she saw him. But it sounds like she saw him face on, certainly from the way that she's been testifying. I don't know if they made eye contact or what, but would his visual snow affect that? Really interesting question. My question, though, is it confirmed by his medical history? I don't know. CJ asks. I don't think we have his medical history. This case, you have to continue to realize, has been under such tight wraps for so long. I believe when this trial gets started, we are going to learn so much that we didn't know already, way more than most trials. My question, though, is if the prosecution opens this door to talk about a medical condition, psychological condition, whatever you want to categorize this as, are they then opening up the door for the defense to get into the autism spectrum disorder, which is something they want to get into? So maybe the prosecution will play it a little careful with all of this. But excellent point, Raffaella from Melbourne, Australia. Aussie, Aussie, Aussie. Thank you for asking. I hadn't thought of that. You win extra points. All right, let's keep it going here.
Hi, Josh. My name is Willow, and I am calling from York, Pennsylvania. I have been watching the show for a while now. I'm a big fan of Courtroom Confidential, but this is my first time calling in, so I'm very excited. My question for you is not related to any specific case right now, but I am currently in paralegal studies. I'm working on my degree, and I am just curious, as somebody that has been on both sides between prosecution and defense. You've been practicing law for quite some time, so I'm sure you've seen it all when it comes to paralegals. Just general across the board, what advice would you give to somebody who is coming into this with pretty much no prior experience in the legal field, kind of learning as I go? And, what do you look for in a paralegal? What do you think makes a really great paralegal? Thank you. And thanks as always for putting on such a great show. And thank you to Caitlin and everybody else.
Yes, thank you to Kaylin and Tiffany and all of our mods and everybody else. And thank you to you, Willow. First of all, let's put York, Pennsylvania on the map. First time caller. I love it. Love it. If you're here, Willow, please say hi. Appreciate you being a supporter for so long and working up the guts to go ahead and give us a call. And I hope it's not the last time. What makes a good paralegal? I will say this. In practicing law, there are always going to be problems. There's always going to be disasters. It's a constant effort of bailing out the ship and plugging up the holes. And there's also going to be mistakes. There's going to be, a lot of practicing law has to do with deadlines and doing things properly and formatting and a bunch of nonsense that really doesn't have to do with whether or not somebody's guilty or not. And mistakes can be made. I will say the assistants and paralegals and law clerks and associates I've worked with before, the one thing I appreciate is if there's a problem, problems can't be avoided, come to me with it quickly and come to me with some ideas and solutions, because we're going to solve this. But rather than just telling me the problems, come to me with the problem, and here's 3 ideas of how we can solve it. And I love that. I love this idea of let's not dwell in the moment that some disaster took place. Let's immediately pivot and figure out how we're going to make it work. So, Willow, my other piece of advice for you is, are you sure? This is some difficult work, but I think you will be fantastic, and I wish you the absolute best, and I hope you'll keep us updated, and I hope you will continue to call in. All right, let's keep it moving. If you're here and you're new, let's hit that like button and get this. I don't know how the algorithm works. I'm just told that if you like the like button, if you hit the like button, it somehow gins up the algorithm. So let's continue to do that and keep it moving along here.
Hi, Josh, from Courtroom Confidential. This is Tracy from Orlando. And my question is, when the defense requests a judge to recuse themselves, why doesn't that motion go to another judge? Why does that judge get to rule on it? Thanks. Have a great Sunday.
Great question. And Tracy, you're calling from Florida. So I'm going to use I don't know if I missed it. Did you talk about Donna Adelson? I don't know if you did or if I just kind of assumed that's what we were talking about, because you're calling from Florida and we recently dealt with a motion to recuse a judge in the Adelson case. And your question is a great question. Why doesn't it go to another judge? Which makes sense, right? If you're challenging a judge and you're saying, Judge, we think you should step off for whatever reason, they're probably not the best person to decide that, right? Like, you probably want another judge taking a look at whether or not that judge is in fact biased. So here's what's interesting. It does and doesn't work that way. And I looked this up specifically for Florida because this is one of those things that varies widely between the states. But in Florida, they have a rule called Rule 2.330, disqualification of a trial judge. Here are the grounds. If the party fears that he or she will not receive a fair trial or hearing because of specifically described prejudice or bias of the judge. So already you can see that it's more than I don't like you. It's more than you seem unfair. It's more than I think you're leaning one side or the other. It's you have to be able to articulate some specific prejudice or bias of the judge. This judge is friends with the prosecutor. This judge has lunch with the prosecutor. This judge, whatever, feels that my type of client is always guilty, whatever it is. My client's a mechanic, and this judge has had awful experience with mechanics and never wants a mechanic to go free again, whatever it is. I will tell you, as I'm talking about this, I'm thinking the last time I challenged a judge, I challenged the judge because he lived on the same block as the prosecutor and had invited the prosecutor over to his house for fundraising events before in the past. And they were friendly in the sense that they would kind of wave at each other in the neighborhood. And I thought, that's enough for me. This is somebody you see on a daily, weekly, if not daily basis. I brought that up with the judge, which is always uncomfortable. And then the judge said, yeah, not happening. I'm not biased. So what do you do next? Well, in Florida, the judge against whom an initial motion to disqualify is directed shall determine only the legal sufficiency of the motion. So not considering the facts, just considering the law, has the motion establish a legal sufficiency. If the motion is legally insufficient, an order denying the motion shall immediately be entered and no other reason for denial shall be stated. This is what happened in the Adelson case. They challenged the judge and he sent back a ruling denying that and gave no reason and had no hearing. And I think that's exactly why this happened, is he felt that it didn't satisfy the legal sufficiency of that motion. Now, if the defense in Adelson wanted to take it farther, they could file a writ, they could appeal that. Any kind of thing like this denied, you can absolutely take it up to a higher court, and maybe they will pursue that. But we don't know the basis for the decision on why they've decided to challenge this judge. And I'll be honest with you, this is just a good judge, and they're never going to be successful with this. I have not heard a word come out of this judge's mouth that hasn't been objective, unbiased, and even perhaps favorable in accommodating the defense for nearly every request they're asking for. In California, we have something called a 170 challenge. We call it papering a judge. Did you paper that judge? I'm going to paper this judge. And you can do that in California one time without reason whatsoever. There are some judges that people just don't like, never want to step foot in front of again. I can think of a few that I feel that way about. And if I ever got assigned to that judge, I'm papering them immediately. But here's the problem with it. It's a gun with only one chamber and only one bullet. And if you challenge that judge and you get sent to a worse judge, you're stuck with that judge now. And the only way that you can challenge that judge beyond that is that you actually have to show bias on the part of that judge. And that does go in front of another judge. So in California, at least, if you're making an objection on a judge based upon bias, not just upon your own challenge, another judge does have to determine that. And if you lose, you go back to the original judge, and now that judge knows that you hate them, and now that judge is even less friendly to you than they were before. So be careful, tread lightly. Great question from Tracy from Orlando, Florida. All right, let's keep it going. Hold on. See, I almost made a mistake.
Hey, Josh. This is JC Broadway from Salt Lake City, Utah. A pretty little bird told me it might be time for another quiz. So everyone get their notepads ready. This is a bar exam sample question. I'm going to do it in 3 parts. I'm going to read the question, and I'm going to call back and give you all the answers or the options. And then I'm going to leave a message with the answer and an explanation just in case I'm, like trapped under something heavy or something and I can't make it to the chat. Okay, here's the question. A college student initiated a criminal case against his former roommate, claiming the former roommate snuck in and removed his state-of-the-art home theater equipment from his house. The college student took the complaint papers that were approved by the prosecution and filed them with a magistrate court. An ongoing police investigation later determined, however, that the college student was a vengeful person, not averse to creating stories, and that he and the former roommate had been arguing over several related issues. They also determined that he never had any quality sound or video equipment. The police dropped the prosecution and the criminal case was dismissed at the preliminary hearing. When the former roommate filed a civil case against the college student, alleging the tort of malicious prosecution, will evidence of the student's reputation for dishonesty be admissible and why? Okay, I'll call again. Hold on.
Love this. JC Broadway, love this. Okay, so this really is boiling down to the question is, when are you allowed to bring in reputation, evidence of reputation? When and how can you bring that in? Now, I'm not going to be a cheater and act like I haven't already listened to all of her messages and heard the answer, but I want to hear you guys weigh in. First of all, we're putting Salt Lake City, Utah on the map. I want to hear you guys weigh in on what the answer is. But to help you out, I am going to give you the federal rule of evidence that is at question here. This is Federal Rule of Evidence, section 405. And that says, if you can't read it, I'll read it for you if I can see it. It says, hold on, I can't read. I've become too old. Hold on. Okay. Methods of proving character. A, by reputation or opinion. When evidence of a person's character or character trait is admissible, it may be proved by testimony about the person's reputation or by testimony in the form of an opinion. On cross-examination of the character witness, the court may allow an inquiry into relevant specific instances of the person's conduct. Or B, by specific instances of conduct when a person's character or character trait is an essential element of a charge, claim, or defense. The character or trait may also be proved by relevant specific instances of the person's conduct. Okay, so with all of that in mind, let's hear the rest of our options here from JC Broadway.
Here are your options. 1, yes, because dishonesty at any time in the past is always relevant to a malicious prosecution complaint. 2, yes, because even though character evidence is too collateral to be admitted for circumstantial evidence, it is admissible if it is directly at issue in the case. 3, yes, because reputation evidence, just like most character evidence, is virtually always admissible. 4, yes, because while most character evidence is not admissible, some is, and reputation evidence is always admissible. Okay, write them down. I'll leave the answer in the next message.
All right, what are your answers? CH says 2. What else do we got? Vesper Martini says 2. Bunny Bella says 2. Kathleen Craghead says 4. Kathy Davidson says 2. I like these. These are some good guesses. It looks like it's between Dr. Magoo says 4. Okay, so it's Cheryl 2, Deanna 2. Johnny Knoxville says 64 because he's bright and cover all your bases. All right, it looks like it's kind of between 2 and 4 here. Let's see what the answer is.
And here is the answer. Drum roll emojis, please. The answer is number 2. Yes, because even though character evidence is too collateral to be admitted for circumstantial evidence, it is admissible if it is directly at issue in the case. The explanation is character evidence may be offered when it is relevant to the material facts of the case, including as here, when the original complainant is now defending himself against an accusation in a civil court of the tort of malicious prosecution, character goes to the college student's state of mind at the time he caused a criminal case to be filed against the former roommate. Malicious prosecution in a civil case is proved by showing that a prosecution was maliciously and without probable cause instituted against the plaintiff and has been terminated in the plaintiff's favor. The college student's character is therefore at issue under these particular facts. See Federal Rules of Evidence 405. And then it states in case law. Hope you had fun. Thanks, guys. Bye. Call me back.
We did have fun, JC Broadway. Appreciate you leaving that question. And a lot of you got it right. You guys see, between AI and just knowing where to find the laws, you guys could be a lawyer. It really doesn't require a whole bunch of magic, but really great question. Not me 2008 says I got a bachelor's of science in law, so I needed to get this right. I went to law school and I still struggled with it. So great job, JC Broadway, and great job, everybody. Appreciate you taking part in the fun. All right. Such a creative caller. I love it. Keep them coming, JC. All right. Here is our next one here. Nope. Sorry. What did I do wrong here?
Hi, Josh. This is Fauna Estep up in beautiful Coeur d'Alene, Idaho again. I just wanted to thank you for having Mark Bowden and Greg Hartley on your conversation episodes, the behavior panels where I first started enjoying YouTube. It's been over 6 years now. My sister, Kathy Lewis in Blanchard, Oklahoma, is the one who introduced me to all of this. Just hoping that maybe you can also get Chase and Scott from the behavioral panel on your show. And something about Mark Bowden that maybe most of you aren't aware, you need to look him up, Nike, Streaker, and Mark Bowden, and see just how good he is at putting himself out there. So just want to let you know how much I enjoy your show. Thanks for letting me have my say, and catch you later on YouTube. Bye.
Fauna from beautiful Coeur d'Alene, Idaho. Thank you so much. Let's put Coeur d'Alene on the map. And this was great. This was another thing I had to look up, and I thank you, Fauna, for bringing this to my attention. First of all, yes, the behavior panel. We have interviewed Mark Bowden. Fantastic interview. You guys should go check it out. If you're a big fan of behavior panel and you're a big fan of Mark, go check it out. We also interviewed Greg Hartley from behavior panel. Also a fantastic guy. All these dudes, brilliant guys. That's why their show is so popular. And you should check that one out. You want us to interview Chase Hughes, Fauna? Done. That's coming out on Monday. We sat down with Chase Hughes. That interview is coming out Monday. And we are harassing poor Scott Rouse to make sure that we can complete our royal flush and get everybody from the behavior panel on an interview. But, all right. Here is what you asked us to track down, and we actually found a clip from the behavior panel. What am I doing here, Kaylin? You know what? I'm going to make, is that not working? She says 1 second. Okay. Am I still controlling it though? Or are you controlling it? Okay. And just give me a thumbs up if you guys can hear this. So this is from the behavior panel YouTube channel.
Scott, what do you got?
You guys got all that stuff. So I'll say
this one's hot. Yeah.
Yeah. So I'll say this. If you'd like to see Mark Bowden run through a stadium naked, it was a Nike commercial. And you can Google that, or don't Google it, put it in YouTube and search Nike Streaker. That's Nike Streaker. And you'll see Mark Bowden naked or nude.
Furlong, Denick. Oh, we have contact. Looks like he has more souvenirs for the crowd. I think he's got the shoes to thank. A minute ago, they were all chanting who had all the pies. I think there's your answer. And he's off like a ball with gas.
If you liked this video, please head over to watch the full video on our main channel.
Scott, what do you got?
That's fantastic. That apparently, I remember that commercial. That was Mark Bowden doing a Nike commercial where he's streaking on the field. So thank you for Fauna for even mentioning it. Here's my only complaint is I wish beyond wish I had known about that Nike commercial before I sat down to interview Mark, because I would have loved to give him a hard time about that. But what a fantastic find. Appreciate you, Fauna, for bringing that up. And yes, go check out our interview with Mark, our interview with Greg. We got the interview with Chase coming up on Monday. I will tell you guys more details about that. And hopefully, I don't know, Tiff, what do you think? Are we gonna convince Scott to give us a little bit of his time? I think we're gonna have to. I don't know what the latest is on that, but Tiffany will let us know. All right. Now I've messed up everything. Let me see if I can make this happen again. Look at that, Kaylin. See? I can figure stuff out. All right. Tell me if you hear this.
Hi, Josh. This is Linda from Red Bluff, California. This is my second question, and it's just a general procedural question. I was wondering why judges don't use gavels anymore. Just curious. Thanks.
I love this. Thank you so much, Linda from Red Bluff, California. Is this our second Red Bluff? Is Red Bluff? Yeah, this is our second Red Bluff call. So thank you for rolling deep from Red Bluff, California. And Linda asks about gavels. And what I didn't realize is that gavels in courtrooms by judges is kind of a uniquely American thing. I did not know that. So I, of course, did the research, looked it up. What the heck is it? Where does it come from? If a gavel, if you don't know, is this little wooden mallet that you hit on a striking board. There you go. And it is to, you see it in TV, you see it in only TV, really, but it's like the judge sits up there, bashes the gavel, everybody comes to order in the court, and it's a way of grabbing everyone's attention. I will say this, first of all. I have never in my entire career seen a judge use a gavel, and I can count on one hand, and I don't need all my fingers, the amount of judges I've even seen with a gavel on their desk. And the gavels that they have are these like ornate gifts that were given to them by somebody in their family, probably when they got their robing ceremony. So it's just become this totally, more of a figure of the criminal justice system than anything else. So where does it come from? Did we ever use them? Apparently, yes. Vice President John Adams used a gavel as a call to order in the very first U.S. Senate in New York in 1789. That's where it came from. It was used for exactly that, just a way to get everybody's attention, call the whole court to order. And I think from that, it just became this thing. The only time I've ever seen, I need a gavel for my bookshelf. I do. The only time I have ever seen a gavel used is in an auction. And that's when you got the, and usually cattle auctions, I feel like. I don't even think you get them. Maybe, no, I think you do. I think like, what are the big hoity-toity auctions? What is it? Is it Sotheby's or something like that? These, big expensive auction houses. I think they do still kind of smack a mallet to indicate that all other biddings are off. Going once, going twice, smack Sotheby's. Yeah. Smack the Christie's is the other one. Yeah. I think they still use like some sort of handheld gavel to indicate that they have ended all bidding. So there you go. Thank you, Linda. Never would have thought of that. Never was really curious till you made me curious. So I appreciate that. And now you guys know. I hope that what I really hope that happens out of this show is that some of you win trivia night at your local pub. That your brains are now full of all of these useful / unuseful tidbits of information that help you in your next pub trivia night. And if you do, just give a shout out to Courtroom Confidential. All right, let's move it along here.
Joel, good morning. This is P. Lola's mom. I'm calling from Mantoloking, New Jersey. And for conversations, I'd like to ask that you be in touch with Broken Baker. Broken Baker is a streamer who is in Denmark and streams all the same trials that we all watch. But the difference is that he is a professional juror in his country. And I'd like him maybe to discuss what the difference is between a professional jurist and us as Americans who do our civil duty by doing jury duty. A lot of people try to get out of jury duty. Maybe he can explain what the benefits are of being a professional jurist. I want to say thank you for your trial coverage every day. Our group is growing and we're having so much fun in chat. And we appreciate Tiff and Kai and we appreciate you. So thank you so much. Have a wonderful Sunday fun day.
And P. Lola's mom, we appreciate you. Huge supporter of the channel. Thank you so much. Always great to see you. I think you're in the chat today, so good to see you. From, here I go. Here's how I butchered this. Mantoloking, New Jersey. Did I say that right? I'm sure. I am positive I did not say that right. First of all, thank you, P. Lola's mom, for the shout out for our new channel. If you guys have not heard about it, we have a new channel called Courtroom Confidential Live Trials. The handle is, there you are. The handle is CC Live Trials. And P. Lola's mom has been over there along with a bunch of you. And our whole concept behind this was, we know you guys like watching live trials. We know that you want a place where you can go and watch them live and chat with people in your community. And we didn't, I still don't, I'm still trying to segue myself from being a practicing lawyer into trying to put more full-time efforts into all of this. And we're all stretched a little bit thin, and we thought we can't do it on the main channel, but let's create another channel just for this. And so that's what we did. It's at CC Live Trials. We're streaming the Karen Reed trial every single day now. Please join everybody over there. And be a part of the chat. And I jump in where I can here or there. I brought on a friend of mine the other day to talk a little bit during the lunch break. I'm going to try to do that more. So please check it out. But P. Lola's mom brings up, how do I do this, Kaylin? I'm going to mess it all up again. Here I go. Just give me a second here. Broken Baker. Why am I having such, there we go. Why am I having such trouble with this? There we go. Broken Baker. I had not heard of Broken Baker. He is a YouTube creator who follows these trials. And he's from Denmark. And so he's got this unique kind of take on the wacky way that we do things over here in the States. Now, the one thing I wasn't able to figure out is about him being a professional juror. And I tried to look into that and how it works in Denmark. And I'll be honest with you, I got a little bit stumped and I couldn't figure out all the answers. So if somebody's got the answer on how that works or can direct me to some sort of resource that I can do a little more research on that, I would appreciate it. But always happy to promote other creators. And it sounds like a lot of you are already fans of Broken Baker. And so I am happy to give the shout out. As a Danish layman passionate about American law, I provide witty, insightful commentary on the latest cases. So there you go. Check out Broken Baker. All right. Let's keep it moving. Thank you, P. Lola's mom.
Hey, y'all at Courtroom Confidential. This is Holly in Houston, Texas. This is for Sunday Funday and the giveaway. I hope that I'll be able to be there, but my family is sick, including me. Yep. So if I'm not, I hope that you guys enjoy yourselves and don't let this be the only time y'all like, sub, share, and come back. We want y'all here. So my question is regarding plea deals. And I love Josh's perspective about this because he is an attorney, and I find that he is he's kind and yet factual. He dances that line real well. So, and what I'm finding, because I've looked at what people are saying about, well, what if he takes a plea deal? Yeah. Well, and I know that also Steve Gonsalves has said that a plea deal is not acceptable. And I get that. But how do they work? I mean, specifically to the Idaho 4 case, because I know the laws are different in every state. What happens if he pleads? Because I want to know what happened. I really do. I've been following this since day one. And I mean, and which kind of leads into the second question I had, the last one. What happens to the sealed documents if he pleads? Do they become unsealed? Are we ever going to find out? Because I think we're all vested and we want to know. Thanks.
Great question, Holly. Always great to hear from you. Holly from Houston, big supporter of the show, and I'm a big fan of you. So thank you. Put her on the map. What a great question about plea deals and Bryan Kohberger. How do plea deals work? Holly actually asked another follow-up question to this about, does the judge play a role in allowing a plea deal or not? All of this is great stuff. So first of all, plea deals, we will never know the substance of a plea deal. Plea deals are specifically confidential. The conversations between the defense and the prosecution, you will never hear them talking about that, how the plea deals worked out. The only thing you will hear is the end result. He has accepted a plea deal for X, but you'll never hear about the back and forth and the discussions and negotiations. Now, in the Kohberger case, Holly mentions how family members may feel like they don't want a plea deal here. As a prosecutor, that's where things get difficult. Your job is to represent the people of the state. Your job is to see that justice is done. Your job is to do the right thing. Sometimes the family members of the victims don't agree with that. Sometimes they want it to be harsher. Sometimes they want to see life or death, the death penalty on every single case because it involves their loved ones and the loss that they're experiencing. Sometimes it works the other way. Sometimes you've got family members who, want more leniency, and you've got to weigh all of these things. You are, as a prosecutor, supposed to give the victims a voice, but that doesn't necessarily mean that you take your marching orders from them. In this case, though, Bryan Kohberger, I cannot see the prosecution offering anything less than the death penalty, honestly. Well, now that I say that, I take that back. I could see if for whatever reason they felt like putting the family and everyone through the trauma of a trial was not worth it. And if he were willing to admit guilt and make certain admissions and tell everybody how it took place and why he did it and unwrap all of the mysteries and questions and admit guilt for life without parole, perhaps. But I think Idaho feels like, listen, we have the death penalty on the books. This is exactly the type of person it's reserved for. Again, allegations, all of that, I get that. But a person who commits 4 horrific murders against young people who are sleeping in their bed, that's the type of person the highest punishment, capital punishment, should be reserved for. So I don't think we're having much plea discussion in this case. The other thing to know is that they can't really go around the judge. A lot of times you can say, okay, I can't deal with the prosecutor. I'm going to go to the judge and say, can I get an open plea? In this case, because it is death penalty eligible, it's not going to work for them. To your next question, let's say in that off chance, Holly, he does take a plea deal. Will we never know anything about this? Well, those documents will likely remain under some sort of seal until the judge orders them unsealed. And that will likely happen, especially if you start to get FOIA requests from investigators, not investigators, but investigative journalists saying release all of this stuff. There's no reason now for this all to be kept private. We want some of this. Now, some of it will probably be redacted to protect the privacy interests of people involved. You don't want a bunch of bloody pictures out there. Things like that will probably never be released, but certainly police reports and things like that, I think would likely be released later on. But they got to worry about, appeals and everything else, and they don't want that somehow being jeopardized. But to your last question about, can the judge play a role in all of this? This is something that is surprising and absolutely infuriating to attorneys, is that, yes, sometimes judges do get involved. You may remember there was a case here in California several years ago, probably around 2015, involving Sheriff Lee Baca. He was the elected sheriff of LA County. There he is. I won't get into all the minutia of it, but basically what it come down to is that there were complaints about mistreatment of inmates in LA County Jail, which is run by the Sheriff's Department. The FBI had started to investigate this. The FBI was actually sending in informants and undercovers to try to speak to people in the department and find out what was going on inside of the jails. In response to that, Lee Baca decides to send out sheriff's investigators to kind of not muscle up, but intimidate the FBI agents, like hitting up the FBI agents. What are you doing? We want to talk to you. It turned into an absolute mess. Okay. He got brought up on federal charges for obstruction, lying to federal investigators, everything else. This turned into an absolute scandal here in Los Angeles. Now, he was 74 years old at the time. He was retired. He was leaving the department in kind of disgrace. Oh, Nancy. Yeah. Sorry. I just saw this flash up. I gotta shout this out here. Mother's Day flowers for Tissus. Absolutely. Happy Mother's Day to all you mothers and grandmothers out there. And dog moms, dog and cat moms, I should add too. Anyhow, back to Lee Baca and his escapades. He gets brought up on federal charges. The federal prosecutors work out a deal, and he's going to get 6 months in prison. He had done something bad, but it wasn't beyond the pale, and they, realizing who he was and his position, his age, and everything else, they thought 6 months was appropriate. Judge Percy Anderson, he's a federal judge here in Los Angeles, and he is known by the moniker No Mercy Percy. And I'll tell you why, because he took a look at this and he said this deal would trivialize the seriousness of the offenses, the need for a just punishment, and the need to deter others. And he said, I'm rejecting it. And it just throws everybody into a tailspin, because what are you going to do? You're going to put now what? Now we have to head to trial. Maybe the prosecution didn't want to head to trial. Maybe they liked this deal. Maybe they felt like they had proof problems. Judge says, doesn't care, put on a trial. So they put on a trial. He went to trial. It was actually a mistrial. Then it went back to trial, and he ended up getting 3 years. So I will tell you, this goes along to another story I can tell you about my own experience. I had a client that was charged with, some pretty bad stuff. But in the course of our investigation, we had realized that one of the victims in the case wasn't entirely being truthful with the prosecution. And that wasn't based upon lying. It was based upon memory. They just had misremembered how some things had taken place. And we actually had video footage to disprove some of that to the prosecution. But this was something that wasn't public. We had a confidential meeting with the prosecutors, and we showed this information to them. Realizing that, the prosecutor said, "Oh, okay, here's the deal we're willing to give your client." And it was a very, very good deal, because they had considered how this could play out at trial. So we had negotiated that. We went to the judge and we said, "Here's the deal we have." And the judge said, "Well, that doesn't sound right. I see what he's charged with here. I'm not going to, how do I accept this?" And I nearly threw my criminal code at the judge, because the whole point is like, Your Honor, you don't know everything. You're not supposed to know everything. We know everything. The people have agreed to this. We've agreed to this. It is a just outcome. We can share with you as much as we can, but we're not supposed to share with you all of the facts of the case, because you're supposed to be objective in this whole thing. But we can share with you enough to know that you don't know everything. Didn't matter. Rejected it. We had to restructure it. Luckily, this wasn't a case that had to go to trial, but we had to restructure the whole deal, and it was a complete mess. So, to Holly's question, yes, sometimes judges get involved. Sometimes they blow up everything. And when they do, it absolutely ignites your hair on fire. So thank you, Holly from Houston, for calling in. And thank you, P. Lola's mom. Oh boy, plenty of flowers coming for her. I'm glad that you guys are helping out, because I have zero ideas what to do for Mother's Day. You guys are going to attack me with pitchforks for this, but Mother's Day snuck up on me, and I turned to Tiff the other night and I said, "What do you want to do for Mother's Day?" And she said, "Absolutely nothing." And I knew it was a trap, and I know it's a trap, and I still don't have anything planned, and I have to figure something out, because she is the mother of 3 beautiful little girls, and she deserves something beyond flowers and a foot rub. So I'll have to figure that out. If you've got ideas, let me know. All right, let's keep it rolling here. Where are we? I'm losing track, Kaylin. All right, here we go. Oop, I got to refresh.
Hi, Josh. This is Maureen from Monterey, and I'm doing my best to try and not sound like I'm on life support. I don't have a comment, and I don't have a question. I'm giving you a well-deserved break from me this week, and I'm just going to sit back and listen to everybody else's questions, because I think they're better than mine anyway. Thank you for coming up with Sunday Funday. It really is the best thing in the true crime space. Goodbye.
Oh, Maureen, that's so touching. I appreciate you saying that. I'm first of all, Maureen, Monterey, California. Let's put it on the map. Thank you for those kind words. That makes it worthwhile. We're working hard. We're really trying to be creative and come up with good ideas and stuff that you guys will enjoy. And Kaylin, poor thing, we work her to death, and she's fantastic and never says no. And Tiffany, on top of being a fantastic mom and wife, she works so hard too. So appreciate you guys so much for those kind words and for all of your support and all of your generosity. It really is helping us. Exhausted and worn thin as we are, we're doing it with smiles on our face. What are we, Kaylin? We're juiced. We are juiced 24/7. I'm happy to do it. So thank you. And I saw Gisela earlier in the chat. There she is. Happy Sunday. I am lurking while working. Always good to see you, Gisela. Also a big supporter of us, and we're a big supporter of her. So thank you guys so much. All right, let's keep it moving along here. Oh, you guys are so fantastic. June says, here's another edition for a spa day. Oh boy, it's turning into a spa day. All right, what trouble did I get myself into here? All right.
Hi, Josh. This is Pam calling from Michigan. I have a juror question. How do you keep jurors from Googling the current cases they are sitting on? I noticed in the Lori Daybell trial that there was a juror that was having issues with staying off his phone. Also, how do you keep jurors from, if they do Google information, from accidentally seeing something outside the courthouse after the verdict was given and being recorded, such as juror number 15 in the Lori Daybell trial? I've also seen a podcast with this juror, and he kind of changed the story a little bit. Now there's a notice that was sent to the courthouse saying that, I don't think they said this juror in particular, but that there was possibly someone that on the jury that had Googled her and may have possibly known about her previous convictions. So what do you do in this instance for this specific juror, but also just in general for any juror? How do you honestly ask them not to and believe that they don't Google the current case that they are on? So hopefully that made sense. Have a great day. Can't wait to listen on Sunday. Thanks. Bye.
Thank you so much, Pam from Michigan. Let's put you on the map. What a great question. What do you do? How do you stop jurors from Googling? Is there any way to do it? How can you be sure that they're not doing it? And what do you do when you got a situation like juror number 15 in the Lori Vallow case? Well, I will tell you this. I didn't know there he is, juror number 15. I did not know the latest in the jury Vallow case or juror number 15 Lori Vallow case. And I thought, I'm stumped, but I'm not beaten. And why is that? Because I can phone a friend. So that's exactly what I did.
What you know, wanted to give you a little insight about Juror 15. Just after verdict, he was outside the courthouse and was asked how he felt. And he said he felt sorry for Lori because driving home the night before, meaning the night before verdict, he was thinking about how she has 3 life sentences in Idaho waiting on her. He acknowledged maybe there was some mental issues there. But as you know, you can't know the night before verdict that she had 3 life sentences. Now, he did give a subsequent interview where he clarified what he meant, meaning he did not know the night before she had 3 life sentences. And Lori filed a motion this week asking for a new trial, citing Juror 15 as one among 3 or 4 reasons she should get a new trial. So I'm sure Josh will keep you guys updated on what happens with this. I think when we heard that, all of our hearts dropped really quickly.
That is GiGi from Pretty Lies and Alibis, and she is a friend of the show. She's a friend of mine, and she was so generous to weigh in on this issue because I know she's been following Lori Vallow since the very beginning and this case very closely, and she knew what was up with Juror 15. And I said, hey, do you mind hopping in front of your phone and giving us an answer? She said, I would love to. So thank you to GiGi. If you guys don't already follow her, which I'm sure you do, please check out Pretty Lies and Alibis. She does incredible work over there. So there's the latest on juror number 15. It looks like it's caused a little bit of a mess. It looks like it might cause some trouble. I will say this. If we misunderstood and if it was misinterpreted, not a problem. If he actually did research on his own, well, let me put it this way. If somehow he became aware by not of his own doing, but just somehow, trying to avoid the media, but couldn't help it, found out about this, probably not as huge a problem if he didn't share it with other jurors or allow it to play a role in his deliberations. But if he actually went about trying to find this out and did searching himself and Googled it and came up with the information before deliberating, could be a very big problem. And to Pam's question, how do you stop this? I don't know. I don't know how you stop it. Do you digitally sequester people? Do you take their phones? Do you put them in a hotel and say you can't look at the news or TV or anything for the next couple of weeks? Here's the thing is, like, a lot of what we do is on the honor system, right? We ask people, do you have any preconceived feelings on this case? We are taking their yes or no as truth. We ask people, and by the way, they swear, they take an oath beforehand that all of their voir dire questions are going to be honest. We ask people, do you have any biases about these types of cases? And we expect people to be honest and forthcoming and all of that. Because this isn't like, what is that movie with Gene Hackman, Runaway Jury or something, where you've got all the technology and the background checks done on these people? That is not the way it works. You're meeting perfect strangers for the first time, and you may have 20 minutes to get through 40 of them, and you're doing your best to figure out who shouldn't sit on this case or not. And a lot of that is premised on the idea that everybody's being honest with each other. And the same goes for, please don't research this case. Please don't talk to your loved ones about it. Please don't talk to other jurors about it. Can we stop people? No. Does it happen? I think yes. And you just got to have a little bit of faith in the system that it's not all falling apart and that they're not all doing a bunch of independent research. And if they are, and other jurors find out about it, that they come forward and say something about it. He failed shut up class. Yes, he did, Afton. But yeah, I will tell you this, if it comes out that he actually did the research, that he considered it, that he even shared it with other jurors, major like retrial problems, like brand new trial for her types problems. But I hope it won't turn into all of that. But thank you to Pam, and huge thank you to GiGi for helping us out with that question. All right, let's keep it moving here. Let me sure. Okay.
Hey, it's Alicia K. Mayo from Humboldt, Tennessee. How's that for specifics? So Kelly Coffey was a Bronx librarian who quit her job due to, quote, unhinged patrons. There was screaming, ripping off of clothes, threats to cut off her toes, and people exposing themselves to teenagers. And reportedly, when she told her supervisor she felt unsafe, they told her allegedly that she was emotionally fragile and being dramatic, and she was allegedly chastised for escalating the incidents and told, again, allegedly, if she was severely hurt or an incident turned out to be fatal, her job would be posted at the end of the week. So I got a couple of thoughts and a question. First thought, as a former prison and psych ward nurse, this is nothing new to me, but this poor lady's a librarian. Second thought, surprised she did not play whack-a-weenie. Now, here's my question. I couldn't find it in any of my research. What's the lawsuit about, Joshua? My husband and I suspect it's hostile work environment, but I'd like to know your thoughts, your opinions, and what you found out. So happy Sunday, Joshua, mods, crew, and guests. Thanks.
Oh, I love you, Alicia K. Mayo. Thank you so much. Humboldt, Tennessee. Just to get specific, I appreciate that. This was one I hadn't heard of too. So thank you for bringing this one up. And what a horrific story. This is about Kelly Coffey. She is was a librarian in the Bronx, and she is suing likely the city and the library I don't know, government function, whatever, whoever's got the deepest of pockets, she is suing. And what is this all over? And Alicia Kay is right. It's about unhinged, quote unquote, patrons. What she's basically talking about is she's this librarian. They've got kids in the library. They've got a kids section. They're trying to run a library. And every once in a while, it sounds like people from the neighborhood, homeless folks, people on drugs, people out of their mind, mental disease, everything else will kind of drift into a library. If you've been into a library in a major metropolitan area recently, it is kind of sad. Some of the folks that decide to make that their kind of daytime hangout area, especially if you want to bring little ones there. Anyhow, putting all of that aside, she talks about people coming in and completely naked, flopping around on the floor, someone threatening to chop off her toes. She talked about one point, somebody came in with his hands in his pockets, started screaming, pulls his hands out. She expects him to have a gun. She's running for cover. The guard runs off. And I think that person eventually strips naked and goes running for the children's section. A lot of this stuff that she talked about involved her trying to protect the children who were in the library. And so she's suing. She's had enough. Well, what is she suing for? You may be thinking, well, how does this have to do with anybody's fight? She's suing the homeless people, the drug addicts. How can you do that? She's not. What she's doing, and what actually sounds like it may have legs, is she is suing her supervisors and therefore the government, because I think it's all run by the government, because she had brought these complaints up to them and they acted like she was being overly dramatic. They acted like she's just overly sensitive and needs to toughen up a little bit, and it's really not that big a deal. And by the way, we have a guard, and what else do you want us to do? So she is suing for, when you're suing, by the way, there's either negligence or intentional torts, and that's about basically it. So she's suing for, I imagine, negligence on all sorts of unsafe work environment, failure to protect, failure for adequate security, for all of those types of things. But then she's also suing for hostile work environment, meaning you did something intentionally to cause me harm. And there's two types of ways that you can charge that in a civil complaint: is either intentional infliction of emotional distress, IIED, meaning you were doing something on purpose that caused me emotional distress, or negligent infliction of emotional distress, meaning your failure to do your job, your failure to meet your duties allowed me to suffer emotional distress. And, depending on the kind of damages she suffered and depending on how bad her supervisors were, their conduct, we could get into some serious figures over this. So it's really sad, horrific kind of commentary, more on big city life than anything else. But that was an interesting story I had not heard of. So thank you, Alicia K. Mayo, from now, very specifically, Humboldt, Tennessee. Appreciate you always. All right, let's move it along here.
Hello, community. Happy Sunday. This is CJ in LA from Los Angeles. Huge congratulations on reaching 30,000 subscribers. What an incredible milestone. I'm beyond thrilled to be a part of such a thoughtful and passionate community. Let's keep the momentum going, share with a friend, and let's get to 50,000 subscribers. So, Josh, I've long been captivated by unsolved true crime cases, not just for their chilling details, but for how the narratives evolve over time. I recently came across the 1987 unsolved murder of Peggy Hettrick in Colorado. A detective who revisited the case said that solving it would likely require nothing short of a full confession, which is really remarkable given today's day and age of DNA. So between mishandled evidence, investigative tunnel vision, and procedural missteps, it's really heartbreaking and befuddling to think of how many cases might remain mysterious and unsolved. And it made me wonder, do you think that cases like Peggy Hettrick's, the Black Dahlia, Benet Ramsey, or the Zodiac Killer may ever be solved, whether through DNA advancements, forgotten evidence, or even, a deathbed confession tucked in an old journal? Thanks for everything you do. Your analysis and storytelling is absolutely remarkable. I appreciate all of you. Happy Sunday and cheers.
Thank you, CJ. I think your questions are absolutely remarkable. I always appreciate your questions. They're so well thought out and presented. And thank you for all your support. I'm a big fan of you for being a big fan of us. And from Los Angeles, California, let's put it on the map. All right. Had not heard of this one. Peggy Hettrick, had not heard of this case. So again, another one that I looked into and another case that is fascinating. This is a case from 1987 out of Fort Collins, Colorado. Peggy Hettrick was 37 years old at the time, and she is found dead in a field. She has been sexually assaulted. Her body has been mutilated, and she has been stabbed. And at the time, they didn't have any suspects, but one person. So she's found by somebody who says they thought she was a mannequin. It's amazing to me how many of these cases start out with people feeling like they saw a mannequin lying in the woods, which makes me believe how many people believe that mannequins just get scattered around the woods. But anyhow, person discovers her body. Earlier that same morning, a 15-year-old by the name of Timothy Masters had walked by her body and thought it was just a mannequin and did not report it. Lo and behold, police figured this out. They do some investigation into Timothy Masters. They find out that he's got what they describe as lots of violent writings, pornography, and a knife collection. Now, he's 15 years old. My first question to you is, how many 15-year-olds have pornography and a knife collection, and maybe they're writing some stories that involve, I don't know, monsters and robots or whatever else have you, whatever. This kid lands on their radar. There's no physical evidence matching Timothy Masters to this killing. No DNA, no hairs, no nothing. In 1999, Masters makes some comments to other people regarding the mutilation of the body. And police believe that that is information that has never been released to the public and only the killer would know. That became disputed because it sounds like maybe some people had known or that information had leaked. However, just based upon he had been there that morning, the violent writings, pornography, and the knife collection, and the fact that he now has, they feel, information only privy to the killer, he is convicted in 1999 for her murder. In 2008, through touch DNA, by the way, I know we're talking a lot about touch DNA these days about whether or not it can be unreliable. Well, here it was tremendously helpful to this young man because they decide there is nothing linking him to him. And in fact, the only forensic piece of evidence comes back to someone else. And he has his conviction vacated in 2008. Just an absolutely wild and insane story, and really kind of got my dander up when I started thinking about the prosecution, police going after this young man with really nothing linking him to it. But, they've got this horrible murder, and it's in Fort Collins, Colorado, and they want it solved. And, if that means taking down a 15-year-old for it, I guess they felt that was the right thing to do. Whatever. I don't know enough about this case to really start, throwing the jabs that I'm throwing. And anyhow, this case remains unsolved. And so CJ says, there's plenty of cases out there. Black Dahlia, John Benet Ramsey, the Zodiac Killer, all of these cases, famous cases we've known for forever. Will they ever be solved? And I agree with the investigator that CJ referenced that when these cases get this old, it's not a matter of, in some it is a matter of advances in technology and being able to go back and pull that mitochondrial DNA that they weren't able to process at the time of the murders, and now they have it, and they feel that they can create a profile and everything else. And sometimes there are scientific advances that can make breakthroughs in cases. But many times, in my experience, when these cases get this old, it's not that there's two things going on. It's either not that they don't have a suspect. They may have a suspect, but not enough to go arrest a person and convict a person. So many of these unsolved cases, Tupac's murder, that wasn't an unsolved. They knew who was involved in that for a very long time. They just didn't have enough to bring charges. There are many cases out there that you might consider cold that they're not. But in some cases, they don't have a suspect. And when they've exhausted all of their scientific evidence, sometimes they are waiting for somebody to come forward. They are waiting for some sort of deathbed confession. And sometimes it happens. In doing this research, I was trying to find, because I felt like there was a case that was a famous case that involved a deathbed confession, but I couldn't find the one that I was trying to think of. But I did find a case of, oh yeah, let's not forget Jack the Ripper. Apparently now they feel, LA, that they have a suspect for Jack the Ripper. I came across this case. I had not heard of this, but I just thought you guys might enjoy this. In 2012, a man by the names of James Washington admitted to the murder of Joyce Goodner, a 35-year-old Nashville, Tennessee woman who was found dead by firefighters inside an abandoned home 17 years prior because he believed he was dying. Well, to James's great benefit and probably huge regret, he recovered from that, whatever that was causing him to feel like he was dying. And they used his confession to convict him of murder, despite him trying to recant his confession several times. So I guess the moral of this story is, if you're going to make a deathbed confession, make sure you're actually on your way out, and it's not something that it's not just heartburn and you're not going to recover from it. I, for one, look forward to my deathbed confession. All right, let's keep it rolling along here.
Hi, this is Heather from Agawam, Massachusetts. This is take 2 because my first one, I think I was rambling. But I have a question about DNA phenotyping. There was a cold case in my town. Her name was Lisa Ziegert. She was murdered in April of 1992. The DNA technology that was used actually showed a composite picture. I think that's what that's called, of the person of interest, and he was arrested and later convicted. So I'm just wondering why DNA phenotyping isn't used more, especially in the John Benet Ramsey case, because there is DNA left from that, along with the Kohberger case. The DNA on the sheath, if they ran it, maybe they could have a better composite picture of him. And just why isn't this type of technology used more in colder cases? I hope this message was a lot more clearer than my first one. Again, this is Heather from Agawam, Massachusetts. Have a good day.
Heather, what a great segue. We're going to keeping it in the cold case realm here from Agawam, Massachusetts. Thank you so much, Heather, for calling in with a great question. And you bring up a topic that I absolutely am fascinated with and love. And I love your question because I feel the same way. So first, she talks about the case of Lisa Ziegert. She goes missing on April 15th of 1992. She worked at a gift shop, and she was closing down the store, and when the owners came the next morning, they find the doors open. She's gone. Her purse is still there. She disappears. 4 days later, April 19th, her body is discovered, and she's been stabbed to death. And this is by the way, in Agawam, Massachusetts. This is why Heather kind of knows the case well. By January of 2013, so this thing has gone very cold. What, we're talking 20 years cold? They do a re-examination of the DNA, which is incredible, and kind of to CJ's point, like sometimes, yeah, there is a scientific breakthrough. And they do because they don't have a match, and that's the other thing about DNA, it's only as good as if you have a match for it, right? You got a DNA profile, fantastic. If you can't match it to anything in some system before where that person has entered their DNA, then all you got is DNA. Same thing with a fingerprint. When they run a fingerprint, they got to match it against something in a database or a suspect, or otherwise it's just a fingerprint. It doesn't tell you anything. Well, DNA actually does tell you something beyond just the fact that it's DNA. And that's where phenotyping sets in. Phenotyping is where you can analyze specific genes and genetic markers within the DNA to infer characteristics like eye color, hair color, skin color, facial features even, and even ancestry. If you've ever done one of these like 23andMe, Ancestry.com type things where you submit your DNA and they tell you where you came from, this is essentially what they're doing. They're tracking down the genetic ancestry of your DNA so they can kind of say what they believe this person, kind of what ethnic background they might come from. But they can also give a likelihood about eye color. You are 60% likely to have blue eyes. You are 90% likely to have brown hair. You are, all of these other types of things. And they can create almost a composite sketch. And that's what they did in this case. I'm going to make this a little bit larger so you guys can see this. Let me see if I can do this right. How do I do this right, Kaylin? I don't know what I'm doing anymore. What am I doing with my life, Kaylin? There. This is what they did. So if you see there, they give kind of statistical analyses of what they believe this person looked like. Skin color, eye color, hair color, freckles, general ancestry, European North and South mixed, Western, all of these general ideas. And here's what they felt that person would look like. Based upon that, I think now this is where the story kind of, I think, skips some steps, but I think based upon that, they were able to narrow down their suspects. And they zero on this guy in 2017 by the name of Gary Skara or Shara, however you want to pronounce it. They hit him up, and Gary admits to the whole darn thing. And so now by 2017, a murder from 1992 is solved through, at least in part, the efforts of phenotyping. Your question, Heather, was why don't they do this more? I got no idea. I think it's fantastic. I think especially in cases where they've gone completely cold, to CJ's question and point, what do you got to lose? If you've got any DNA, let's do something with it. Heather mentions the John Benet Ramsey case. There is DNA in that case. Can we get an idea of just general characteristics at least? So anyhow, my view is why not? I don't get why they don't more. Maybe they do and we just don't hear about it. But great question. Heather from Agawam, Massachusetts. Thank you so much. All right, let's keep it rolling here.
Hello, Joshua and Courtroom Confidential friends. My name is Kimmy, and I am from Maine. I've called before, so you already have me on the map, but if you wanted to fine-tune it, I am in Turner, Maine, which is about 20 minutes from Lewiston, home of the strong and the brave. We had an active shooter situation a couple years ago, and unfortunately had a very close encounter being right next door to the bowling alley at my place of work when that happened. Anyway, to get past that, I had a question about a case I was watching about a teenager who killed his mom in self-defense. From what I understand, in this trial, they weren't allowed to bring up the past conviction of killing his father. Well, I have such a hard time with that because, like, if I was on the jury and, knowing now what I didn't know, during the trial, I would be devastated knowing that, you know, this kid got off killing his mother after killing his father. Can you tell me what the standard is on that? Is that something that is typical? And what are your thoughts on it? Thank you so much. Take care. Bye.
Thank you so much, Kimmy. First of all, let's put Turner, Maine on the map. I don't think we've had Maine before. Maybe we have. I don't know. We got a lot of dots going on there. How do I make it bigger, Kaylin? There we go. Look at that. God, I love to see this. This is so great. Thank you again, Kaylin, for putting this together. All right. Kimmy from Turner, Maine, next to Lewiston. Incredible tragedy. I don't want to kind of skip over that happened there. This was back in October of 2023. 18 people lost their lives tragically. Robert Card was eventually the gentleman, I know I get yelled at when I use that word, the man who was responsible for this. He ended up taking his life 2 days later. So that was out of Lewiston, Maine, close to Turner. And Kimmy, you know, our love and prayers continue to go out to your community. But Kimmy is asking about a case out of Florida, actually, involving a young man by the name of Collin Griffith. He was actually 17 years old when in 2024, he is involved in an altercation with his mother and kills her. And he claims self-defense, and he was actually acquitted of that crime. And it wasn't so much that he was acquitted of killing his mother that really drove everyone nuts, but it was when you realize that 2 years earlier, in 2022, he had shot and killed his own father back in Oklahoma. And he also claimed self-defense there. The reason he was living with his mother in Florida was because he had killed his father after claiming self-defense, and was a troubled young man and having, some difficulties with his mother, and got into a fight with her and killed her. And people were beside themselves that it seems like now he has killed both his parents and gotten away with it. I will say this: one, the case in Oklahoma was never filed. So they can retry him or they can try him for the first time on that if they choose to. And it sounds like Oklahoma is giving a real close look to that case. But secondly, Kimmy is bothered by the fact that the jury didn't know about it. Well, they did know that he had had a prior shooting where he had taken someone's life and that he had claimed self-defense. What they didn't know and what they were not told was that that person was his father. And Kimmy is bothered. Why weren't they told about that? Well, this comes down to something we talk about often, which is prior bad acts and character evidence. We are very concerned with anyone ever being, and rightfully so, anyone ever being tried and convicted merely for who they are and not what they did. So your prior bad acts should not play a role in what you're currently being charged with, unless those prior bad acts are proving something else. Are they proving motive? Are they proving opportunity? Are they proving intent? Are they proving preparation, plan, knowledge, identity, absence of mistake, or accident? So if you can show that this prior bad act is proving something other than this person's character and why they're a bad person and should go to jail, then you can use it. But I think more than anything, Kimmy, in this case, what it comes down to is a judge is always doing a balancing act between prejudice and probative value. Meaning, is this evidence, though it may be probative, is it too prejudicial to bring in? Will it cause the jurors to treat that evidence in a way that's inappropriate? In other words, will jurors hear that he killed his father in self-defense and think, okay, ain't no world I live in that has the chances of this happening again. I'm going to convict him. And therefore they're convicting him on something that he's not charged with and not based on evidence surrounding those current charges. And I think the judge just felt by telling them it was the father, it was too much. It was too much and created too much of an invitation for that kind of error on the part of the jurors. And they didn't know about it. and they found out about it afterwards. And now we're all a little beside ourselves. Anyhow, stay tuned on that case, though, because I think that we will be hearing from this young man again. And I'm hoping that doesn't have to do with him killing someone else. I'm hoping that has to do with Oklahoma taking another hard look at that case. But great question for that. All right. We got a few more to go here, guys. We're getting to the finish line. Stick with me. Don't go anywhere. Big giveaway happening. 30K giveaway.
Hi, Josh. Dorothy from New Jersey. Will you be attending CrimeCon this year? Thank you.
Hello, Dorothy from New Jersey. First of all, you go on the map. And secondly, yes, we will be attending CrimeCon this year. It will be our first year at CrimeCon. We plan to have a booth. I've been to CrimeCon before, but this will be our first year when Courtroom Confidential is going. It's in Denver, September 5th through 7th. If you guys are able to come, please come. I think you will enjoy it. I will tell you, I went to CrimeCon in Nashville. Oh, Shell's going to be there. That's how Shell and I met each other. It was in CrimeCon. Tiffany's going to be there. Kaylin's going to be there. It's, going to be a whole family affair. I went to CrimeCon in Nashville. First CrimeCon I ever went to. I was blown away. It was fantastic. It was wild, the energy and the enthusiasm of everybody. And I really, really looked forward to it. And I think you guys will do too. If you've never gone, you should go. If you've gone before, please come to CrimeCon in Denver this year because we will be there. And I'll just shamelessly kind of plug too. The CrimeCon gives out these awards called the Clue Awards. And we are hoping to kind of pitch ourselves for the Misconduct says it's on your bucket list. Let's make it happen. We got till September, Misconduct. They have a People's Choice Creator of the Year Award by CrimeCon puts this on in their Clue Awards, where it's somebody you nominate a creator, and it's all voted for by the people rather than by a committee of folks. And I guess I'm shamelessly offering ourselves. If you guys want to nominate us and vote for us, we'd appreciate it and would love the support, but we will definitely be at CrimeCon. We hope to have a booth, and I hope to maybe be a part of some presentation. So stay tuned. Thank you, Dorothy from New Jersey, for asking that question. Everybody buy your tickets now. All right. Let's keep it going here.
Hello, all. I'm calling from the Saskatoon area of Saskatchewan, Canada. And my question is, I heard Karen Reed say that she is not paying her defense team. Does that mean they're court appointed, or is it like a pro bono deal or something? And do you know if Bryan Kohberger's team is appointed or hired? And is there any way that we can tell, or do you just kind of have to wait until somebody says something? Thanks so much. Bye.
Jenny, thank you so much. Calling from, you pronounce it Saskatoon. I want to say Saskatoon from Saskatchewan, Canada. Whatever, that's where you live. I appreciate you calling. I think that's our first caller from that area in Canada. Thank you so much, Jenny. Does Karen, she has said her team is working for free. She's not said she's not paying them. She says they're working for free. And Jenny wants to know, are they pro bono? Well, I will tell you this. I have no firsthand knowledge of the arrangement that has taken place between Karen Reed and her attorneys. I've known Alan Jackson. I've known Liza Little for very long. And I will tell you, they are not working for free. Alan Jackson is not a cheap lawyer, and he's very busy, and he's got a lot of people who want to hire him. And he is not doing this for free. He's got David Yannetti, don't know what he's got going on. Alessi, not sure about his involvement. But what I believe is happening, and again, I don't know this, don't come at me. This is just my guess. I believe what's happening is they are working without asking for payment now. And it's more of an idea of let's settle up accounts afterwards, because I know that she has also made reference to legal fees mounting up and, done even fundraisers to help her out with the legal costs of all of this. So I imagine this will be one of those things that when this is all, the dust settles on all of this, they'll settle up. But I don't think that this is just everybody working for free on this whole thing. It's just far too involved and far too much time away from other clients and far too expensive to put on a defense like this. Maybe Kraken Studio, The Real Booty, has some insights saying, Josh, I believe Ellen has said that she was paid into what she has paid into already. The other lawyers aren't taking additional funds. I believe like Alessi is pro bono, but I could be wrong. You could be right too. I don't know. I mean, that's the thing about private attorneys, is they can structure this however they want. It could be, we'll pay you on the back end. We'll give you part of this, TV deal, book option, what have you. Or Alessi could be like, I just want to be involved. I'm happy to do it. I don't know. Alan could have been paid already. Who knows how this whole thing is being structured, but they are private attorneys. I will put it to you that way. They are not court-appointed attorneys. Bryan Kohberger, on the other hand, does have court-appointed attorneys, meaning the state is providing for them. They are taxpayer paid, just like, public defender's office. Many states have public defenders. Los Angeles even has what's called the alternate public defender's office. And then many states have what is called bar panel, meaning private attorneys who are appointed on particular cases by the state and paid through the state. So all of that meaning it's not coming out of the pocket of the client. And Ann Taylor is court appointed, being paid by taxpayer funds. Thank you, Jenny, from Saskatchewan, Canada. Appreciate you. All right. We're down to the wire here. Last couple of questions. You nominated me, Rowena Rains. I appreciate you so much. You're the best. All right. Where are we at?
Hey Josh, it's Objection Kate calling from Langley, BC. I wanted to ask you more about what we were talking about last Sunday, how defense attorneys can't put their clients on the stand and ask them questions if they know they're going to lie. So first of all, wouldn't that be sort of a tell now to a jury if anyone on the jury knew that that's the case, that a defendant can only testify in narrative form if their lawyer knows they're going to lie? That would be a huge tell. So I'm wondering if there's any, do they do a jury instruction or something like that? And then also, how would anyone know that the lawyer knew they're going to lie, because their conversations are privileged? And then, sorry, but my third part of that question is, and I might be wrong, but I thought I remembered in one of the motions hearings with Lori Daybell and the judge there that he had warned her that if she were to testify, it would not be in a narrative form and her assistants would be asking questions. So I'm wondering there, what if she wanted to do a narrative and the assistants knew she was going to lie? Anyways, that's my question. I'm running out of time. Thank you so much.
Thank you, Objection Cake from Langley, BC, Canada. Appreciate you. You're going on the map. One day, Objection Cake, I want to know where that name comes from. I love that name, Objection Cake. I feel like I want to serve up a slice of Objection Cake sometimes when I'm listening to these trials. Great question, though. First, would it be a tell when a client, a defendant testifies in the narrative? Wouldn't that just signal to all the jurors that this person's about to get up and perjure themselves? The answer is maybe. We hope that the jurors don't know that already. You guys know that, but a lot of people don't know that. They don't know any different. This is the first trial they've ever watched in their whole life. And the the defendant gets up there and starts to testify and just keeps on talking, and they don't know there's anything really all that different about it. They're not told ahead of time, all of the ins and outs. They might be told, they're going to give their testimony now and we're going to allow them to just tell their story, but they're not told, how this is different and all of that. But some may know that, and they may kind of put the pieces together, and that could be an issue. And again, we'll only know if the jurors are honest about it. And hopefully those jurors don't tell other jurors about it. The other question you said was, how would anyone know that the lawyer knew they were going to lie? So this is an interesting question. I think where you're going with this is, if the conversations between an attorney and the client are privileged, then how would anybody ever know that this was about to be a lie here told, and that's why they're asking for a narrative form? The answer to that is that most likely in camera, the attorney will go back and speak to the judge, meaning in chambers, private, not off the record, but under seal and without the prosecution present, and say, here's what my client's going to say. I know that this is factually untrue. There's a difference between factually untrue and just he's going to get real creative with his story. An attorney cannot put on something factually untrue, suborn in that perjury. But if the client just has a interesting story to tell, that's not necessarily perjury, and you often see lawyers still participate in that questioning. But this lawyer feels, I ethically cannot take a part in this. I'm going to let the judge know in private and in chambers and under seal. Then in court or back in chambers still, they will let the prosecution know, I'm going to allow the defendant to testify in narrative. And that's all the prosecution will know. The prosecution doesn't get to turn to the defense attorney and goes, what's he going to lie about? They just know, okay, everybody okay, wink, wink, nod, nod. I get it. We're going to have narrative form here. And the judge will allow then the defendant to testify in that way. But to your question about Lori Vallow, you are not entitled to that. In the case of an attorney asking for it, that attorney is saying, I don't want you to put my bar card at risk, judge. But in the case of Lori Vallow, he doesn't know what she's going to testify to. She's not entitled to testify in narrative form. And so therefore he can deny her doing that. And I think the reason the judge in the Lori Vallow case I thought he was a very good judge, first of all, because he doesn't want the whole train going off the track. He realizes if he just lets her get up there and start telling a story, we might still be there listening to her. So he wants this kind of done in a more structured way. And therefore he was going to allow her, if she did testify, to testify through her support counsel, asking likely very scripted questions and just getting her answer to those things. Which, by the way, shock of all shocks, and I'm still disappointed that she never took the stand. Josh, have you had to do this? No, I have not. I have seen someone testify that way, though. I have had a pro per defendant who testified that way. I was the prosecutor, obviously, but I've never had to ask a client to testify that way, because mainly most defendants don't ever take the stand. And if they were going to lie, we would be having some very serious conversations about my representation of them anyways. Okay, great question. Objection cake, Your Honor, from Langley, BC, Canada. All right, everybody, here we go. Last one.
Hi, Courtroom Confidential. This is Sonia from Chicago. I have a question. Of course, you all know it's going to be Karen Reed case. So here's my question. There's a lot of talk that somebody is going to break, whether it's going to be Brian Higgins or whether it's going to be Proctor, actually. What if they break on the stand? What happens? I mean, does Alan stop the whole thing and then go for a dismissal? Do they stop the whole? I mean, how does that work? What if, for example, Proctor started telling the truth about what happened on the stand? What would happen? And has that ever happened to you before? I'm looking forward to your answer. Thank you. Bye, guys.
Sonia, love to hear from you. Always appreciate all your support. Putting Chicago, Illinois on the map. Sonia asks, on the Karen Reed case, what happened when you say breaks on the stand? I'm imagining you have this scenario in your head of Brian Higgins saying, all right, I've had enough. You're right, Mr. Jackson. My dog attacked him. I beat him and we dumped him in the snow. Or Trooper Proctor saying, Mr. Jackson, I can't keep up with you any longer. You're right. I grabbed the taillight pieces and I sprinkled them all over the lawn, and I did it then and I'll do it again and you'll never catch me. Ha 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 ha. I don't think, first of all, that universe exists. I think it would be absolutely beyond wild and it's insane. And what would Alan do? Alan's hair would immediately and instantly combust into fire. That's what would happen. It would just absolutely, there he is. Imagine that head on fire. It would absolutely be one of the most spectacular things you'd ever see happen in court, for somebody to actually, quote unquote, break. Not going to happen. Don't think it'll happen. But what would happen? Well, after Alan put out his hair, no, you don't ask for a mistrial. What you do is you turn immediately to the prosecution. You go, what are you doing here? Dismiss your case. And if they don't, then I guess legally what would happen is you would wait until the people rested, and then you turn to the judge and go, end this. You heard perjury. You heard them admit everything. End this case now and leave it up to the judge. And if all of that fails, then you have yourself a just absolute, Burning Man celebration type closing argument when you're laying this whole thing out. So again, Sonia, I get it. But I think that stuff only really happens in the movies. I think the closest I've ever seen, or the closest you will ever get, I mean, this is not going to be, what was it with Jack Nicholson and I Want the Truth? You Can't Handle the Truth. Why am I blanking? Few Good Men, one of my favorite films. This is not going to be you're goddamn right I did. I ordered the code red type of a situation. The closest I've ever seen is just where people kind of just break down. I don't want to talk anymore. I'm done. Yeah, whatever you say. And they just kind of turn into this kind of childish, melting in front of your eyes. But I've never heard anybody say, I did it. Yeah, I did it. Anyhow, great question to go out on. That was fantastic. This is one of the best Sunday Funday ever. You guys asked incredible questions. I mean, we talked about Karen Reed, and we had a special guest appearance from GiGi. We talked about some cold cases. We got to see Mark Bowden run around naked on a soccer field. And it was a really fun day. Thank you guys all for all of that. All right. Got some announcements and a 30K giveaway. Let's go through this because I know you guys don't want to wait and you want to get on to your day. First of all, Saturday. If you missed it, we did our weekly roundup. Please go check it out right now. It is on our channel. We talk about Karen Reed. We talk about Sean Combs. We talk about Bryan Kohberger. We talk about Donna Adelson, all the latest that took place this week. Check it out. In 30 minutes or so, you will get updates on everything that took place. Then coming out Monday, tomorrow, is our conversation episode, our latest in the series, where we sat down with Chase Hughes from the behavior panel. These guys, the behavior panel, are just fantastic, fascinating dudes. Every single one of them has been a fascinating story, and Chase is right up there with all of them. And I will say that I'm in good company because Chase was actually interviewed by Joe Rogan not that long ago. So, he's doing the Joe Rogan show. He's doing Courtroom Confidential. He's making the circuit, as we say. That will premiere, though, at a different time because Chase said to us, by the way, we've got a big audience from the UK, and it might be nice if you change your release schedule so they could join in the live too. And we said, that's a fantastic idea. So for this Monday, we have a new release time. It will be at 2 p.m. Pacific, 5 p.m. Eastern, and that makes it 10 p.m. in the UK if I'm doing my math right. So stay up a little bit later, all of my British friends, so that you can watch us sit down with Chase Hughes from the behavior panel. That is taking place tomorrow on Monday. And then on Wednesday, for Wednesday Night Live, we're going to have Anjanette Levy from Crime Fix and Long Crime join us, talking about some cases she's been following closely. I know she's on top of Bryan Kohberger. I know she's on top of Karen Reed. I know she's on top of all of these cases in the news, and I love her and I love her thoughts. That will be this coming Wednesday at 5 p.m. Pacific, 8 p.m. Eastern. Sorry to my UK friends. Just set an alarm. Wake up. What is that? 2, 3 in the morning? Just set an alarm. Who cares? All right. Oh, we've got, let me just share with you our website really quickly, because I feel like I don't really explain this enough, and it's something that we're very proud of. So if you guys go to thecourtroomconfidential.com. Oh, am I messing this all up, Kaylin? How am I going to do this? There we go. Couple of things I wanted to talk to you about. First of all, we have brand new merch. If you click on the shop, this is where you can find all of the new colors and new designs and new hats and mugs and all of the good stuff that we've been offering. And this is part of what's happening in the giveaway today. We're going to be giving you, whoever's our winner, one of these brand new shirts. But in addition to finding out where you can send us a voice message, you click on the send a voice message for next Sunday's show. Please check that out and leave us. I've already seen that we've got some new ones as of this morning. The other thing I wanted to talk about was becoming a member. If you click on become a member, you can join the Courtroom Confidential crew here. And I feel like I don't really tell you about the amount of work that we put into this. We really work hard on making this worth your while and something that is an added benefit. So we do weekly members only videos. We do members only giveaways. We do members only, polls and interactions and behind the scenes features. And we do a once a month members only live stream. So we're really putting a lot of effort into making sure that this isn't just some sort of add-on, but it's actually something that you guys will enjoy. So please check out the membership. And then lastly, go to CC Trials. Let me see if I can find this easy enough. I can. Go to @CC Live Trials for our new YouTube channel, where we are going to be covering, as you can see, we've been covering every single day of the Karen Reed trial. And subscribe, set your notifications so you can join everybody in the community to watch this Karen Reed trial and any upcoming trials live on that channel. All right. That's all the stuff I got for you. Stephanie, for becoming a member, thank you so much. Do I have anybody to, any thank yous that I missed, Kaylin? I don't want to miss all the thank yous. And then we're going to do our 30K. Are we all good? Kaylin says we're all good. We're going to do our 30K giveaway. So drum roll, please, for leaving a comment. The winner of a new shirt is Willow. Fantastic. That's Willow from York, Pennsylvania, who I actually think said it was her first time calling in, that she'd been watching us for a while, but it's her first time calling in. So thank you. Thank you so much, Willow, for being our winner. You see, we had a ton of entries. Congratulations, Willow. Willow, this is all you got to do is email us at media@joshuaritter.com and tell us where to send this. Tell us what shirt you want and where to send it, and it is yours. So thank you so much, Willow, and thank you to all of you for your support and for growing Courtroom Confidential into what it is, and for being here with me this morning. And a huge thank you to Kaylin and Tiffany for all the hard work that they do, and to our mods for all of the hard work and support that they do. Appreciate you guys so much. Thank you again for 30,000. Appreciate it. Let's keep it going, everybody. Have a great rest of your weekend. Take care.